Thank you for tuning into this video titled Top 10 Things All Entrepreneurs Must Know About Trademarks. My name is Xavier Haley, and I'm a registered patent attorney with the United States Patent and Trademark Office. I practice law in the area of intellectual property and business law. Today on our agenda, we will discuss what is a trademark, how do you obtain a trademark, the difference between common law versus federal registration, the types of trademarks, choosing a trademark, spectrum of distinctiveness, selecting an international class, trademark searching, different types of U.S. application, and U.S. registration timeline. Let us get started. What is a trademark? A trademark is a word, phrase, symbol, and/or design that identifies and distinguishes the source of the goods from one party from another. In other words, a trademark operates as a source identifier. It identifies and distinguishes goods or services. The purpose of trademark is for consumer protection, to avoid confusion in the marketplace. How do you obtain a trademark? Trademark ownership is acquired by actual use of the mark in commerce. If you don't use the mark in commerce, you don't have a trademark. You have to use the mark to such a degree that the public identifies that the mark originates from a single source for a given product or service. The difference between common law versus federal registration. As you see in a table before you, common law, there's no registration required. You have to actually have use in order to have a trademark. The scope of protection is only the geographical area in which the mark is used. You can use the symbol TM, which stands for trademark, and SM, which stands for service mark, and the jurisdiction falls under state law. As compared to federal registration, you have to register the mark with the United States Patent and Trademark Office. Actual use is required, and the use has to be interstate commerce. The scope of protection is nationwide, so all 50 states and the territories of the United States. The symbol is the registration symbol, R, also known as the circle R, and the jurisdiction falls under federal law. The different types of trademarks. There are two types of trademarks. You have word marks and you have special form. Word marks is pretty much what it says. It's a mark that's words. There's no stylistic component to it. There's no particular font, size, style, or color regarding that mark. As compared to a specialized form, which can be stylistic or have a design, there's some design element to that mark, or there might be a word in such as a stylistic form, as you see in the screen with the Coca-Cola on the bottom portion. One thing to know about word marks is the strongest mark compared between the two, because it takes the broadest scope. You're not narrowing it down based off font, size, or color. When choosing a mark, the mark must be distinctive, which means it identifies a single source for a given product or service. Inherently distinctive marks are trademarkable. In other words, it's easy to get a trademark. They are strong marks. Distinctive marks can be like Pepsi, Google, Yahoo, words that are made up or invented to function as a trademark. Marks that can acquire distinctiveness, such as IBM or International Business Machines, because IBM sells machines, probably by marketing to the marketplace. Now, generic. There is no protection for generic marks. You cannot get a registered trademark if the mark is generic. For example, smartphone. And the goods are selling cell phones. Therefore, there's no protection for that. The spectrum of distinctiveness. As you see right here on this graph, there's three categories: fanciful, arbitrary, and suggestive. If a mark falls within those three categories, it is a strong mark, and there would not be any issue in terms of distinctiveness with getting that mark through the Patent and Trademark Office. Now, if the mark falls below the red line, such as descriptive, there will be an issue with getting that mark registered with the United States Patent and Trademark Office. And you will have to show secondary meaning, which means you have to show that the public identifies the mark originates from a particular source. Now, back to generic, there's no protection for generic marks, period. Selecting an international class. When filing a trademark application with the United States Patent and Trademark Office, you have to select a class in which the mark is filed. A class operates like the industry in which the mark is being used. Like for example, if a person is selling the goods, a t-shirt, that will fall under class 25. The Trademark ID Manual provides a list of classes covering goods and services. Trademark searching. A trademark search is not mandatory for filing a trademark application, but the benefits of a trademark search can save you money in the long run by identifying issues that can prevent registration of the trademark or lead to potential trademark infringement if you were to register your trademark with the United States Patent and Trademark Office. In terms of obtaining a trademark search, make sure that the trademark search covers federal trademarks and common law, such as searching the state database for trademarks and the state database for corporation names. Now, the different types of U.S. application. There are other types of application, but I'm just going to list the common two, which is use in commerce application known as 1A and intent to use application known as 1B. A 1A application is for marks that's already being used in the marketplace. With a 1A application, you put everything together in the application and submit it all at once, which means that to get to registration, it will be faster as compared to a 1B application. A 1B application is that the mark has not been used in commerce, but you intend to use the mark in commerce in the future. With a 1B application, you don't put everything together in the application when you file it. You actually file a specimen or evidence showing that you're using the mark later on in the process. As a result, you have to pay an additional fee. Now, the timeline for registration of a trademark application goes as follows, as you see on the screen. Research and drafting. Research is like conducting a trademark search and searching the ID class manual to make sure it's the proper class. Drafting is preparing the application. The next step is filing the application with the United States Patent and Trademark Office. Once the application is filed, it takes between 3 to 4 months before the trademark examining attorney picks up the application and reviews the application. Once the trademark examiner reviews the application and conducts their own trademark search, they may issue an office action. If they issue an office action, which means there's a deficiency in the application, you have 6 months to respond. If you're not able to overcome the office action, your application will go abandoned. An abandoned application means that the Patent and Trademark Office is no longer examining or looking at your application. If you overcome an office action or did not receive an office action, you will go to the publication phase. Publication, there's a 30-day window where the public can oppose the trademark application. If there's no opposition to the trademark application after the 30 days windows, the trademark goes to notice of allowance. Depending on the type of application that you file, if it was a 1A application, which is use in commerce, after notice to allowance, you move on to registration. Now, if the application was a 1B application, intent to use application, instead of moving to registration, you have to move and provide something called statement of use. Statement of use is just showing how the mark is being used in commerce. Pretty much it's the specimen. Now, once a statement of use is approved, you move to registration. If there's any issues with the statement of use, then you may receive another office action. Now, if you don't file a statement of use within time and don't have an extension, your application will be abandoned and you have to start the process all over again. That concludes my presentation. Hope this video was very informative and very useful. Thank you for watching.